jump on the broadcast. Good evening. I hope and believe that I'm live and the people that have registered can hear me. My name is Brad Micklin. I'm online to do my monthly webinar, which tonight is How Do New Jersey Fathers Modify Child Custody During the Pandemic? If somebody could just do me a favor, and you should have a chat panel on your right-hand side, and type into either where it says questions or chat just to let me know if the audio is working. I also have my camera turned on because I thought it'd be decent to have my face that you're looking at when you're watching the webinar and PowerPoint, but I'm not sure if that's actually showing or not. So let me just see if somebody can tell me if they're hearing me. I always get concerned that people can't. I've had some technical problems from time to time where I do a full webinar and there's no sound. Okay, so your audio is good. Great. Thank you for responding. Can you let me know if the camera is working? Does it show anything other than the PowerPoint? Just PowerPoint. All right, well, it could be something with my camera on my laptop, but no loss. PowerPoint's better to look at than I am anyway. All right, so let's jump into it. Today's webinar is set to be 60 minutes. I never hold rigid to that. I talk as long as I think it's necessary to get through the information. I try not to waste your time, obviously, but I try not to speed through it because a lot of places, there's a lot of information. Sometimes it sounds a little tedious to listen and hear me reading it all, but it is usually very important to get this kind of details. So I take my time as I can going through it. There is a PowerPoint attachment attached to the handout section on the chat panel. If you have any interest in copying and reviewing it, it will list certain statutes and the criteria for certain matters that may be helpful to you if you want it. There's also a place for questions you can type. I recommend people type the questions whenever it comes to them, but I don't answer them until the end of the webinar. That way I don't start messing around with getting in and out of the PowerPoint. Plus, it may answer your question before we get there, but I will take as much time as necessary afterwards to answer all the questions. So without further ado, so actually let me click out webinar viewer. I'll leave it up. That's how it doesn't matter. Okay, so this is me. My name is Brad Micklin. I am a licensed New Jersey attorney in state and federal district courts. I'm the founder and managing member of the Micklin Law Group, which is a law firm concentrated in men's and fathers' rights in divorce, custody, and family law matters. Offices in Nutley and Montclair, New Jersey. I have been fortunate enough to receive some awards and accolades from clients and contacts. Here's a list of them, some of them at least, and the criteria for them. I don't put this up to try to impress people, but to impress upon them that I've been doing this for some time. I do believe I'm reasonably skilled and experienced enough to help you with this information. The purpose of putting this up here is just to give you some reference. You know, in my experience, people don't often know even what to ask when they have topics to speak with their lawyers because they have no experience with it and they have no language or background to understand even what's being discussed. So the purpose of this is to help you along. The reason I put this information up is just so that you have some sense of my background experience. Also am a media consultant on legal issues. I've been fortunate to appear on Inside Edition, CNN, Larry King, I-24, Fox News, and a bunch of others. Again, just to give you my background, whether that means something or not is up to you, but fun to do, and you can also see some of my clips on my website and my YouTube page. I am actually going to close the window that says webcam with the hopes it doesn't mess anything up. All right, so let's talk about child custody during the pandemic. I'll give you first just an overview of what we're going to talk about. Broadly speaking, as far as overviews, parenting time is an essential activity. It's not part of the governor's lockdown 6-foot social distancing protocol. There still is no change to parents' rights to have time with their child. If there is a court order in place, they're obligated adhere to it and follow it as best as possible. When I say adhering to it, both parties are responsible to adhere to the parenting time. Custodial parent who has the child most of the time is required to provide the child for parenting time, as well as the parent who is supposed to have parenting time is required to take the child and exercise that time. Most people think it's just a one-way street where the custodial parent needs to provide the child, but compliance is on both sides. So if you're missing your parenting time, for instance, you would be in contempt. It's not like you have the schedule and it's your choice whether or not you exercise it. Sanctioning on either side is actionable by the court. The court is able to sanction financial, legal fees, reducing or increasing parenting time, change of custodies, and various other remedies available. If there is no court order, technically you're under no obligation to provide your child to the other parent for parenting time, nor are you required, if you're the parent exercising parenting time, required to return the child. Now, I'm not suggesting either side take this kind of position. You have to exercise caution when refusing parenting time even without a court order. There's obviously the interest of your children and their best interest at heart. There's fostering a relationship and cooperation. And there's also going to be issues possibly later when the courts are brought into your matter to determine good and bad faith positions and custody rights when determining who would act in the best interest of the children going forward. Courts will often look to past actions even when there was not a court order for parenting time. So the access flexibility of the current custody order, parenting time order during your quarantine. So first, you need to look at your court order, and it says here marital settlement agreement. There really could be many other types of agreements. It might be consent orders, which is a court order that you two sign, and then the judge signs, becomes a court order, but it starts as your agreement. You want to look back over that because you need to make sure that you understand the schedule that you're supposed to have. Summer's approaching, so the schedules may have changed or set to change under your schedule that may not be the same that you're exercising right now. You may need to also determine with, even though what is or isn't working now is going to be changing, you need to determine how that's going to change. So you need to understand what the terms are and when it's supposed to change. Now, that isn't to say that you're locked into your schedule. We as practitioners generally view a parenting schedule as sort of the basement level of everybody's obligations, meaning when you need to get to the bottom of something or a dispute, go by that and you're bound by that. Everybody is free to change by agreement. I usually recommend that you have that change in writing so that it's clear what people have agreed to and have not agreed to, and some people are less than forthcoming when they make an agreement that isn't in writing. So even any agreement, but if you're going to be modifying parenting time and you think there's going to be parenting issues, make sure it's in writing. It could be an email. It doesn't have to be a text message. It doesn't need to be anything fancy. It doesn't need to be signed by a court if there's an agreement, although it would be best to do that, but it's a little more formal than you need for this kind of an issue. Let me give a quick hello to some people signing on to my Facebook page. Glad to see you guys here. I never welcome anybody by name because you can't see everybody else unless you're mutual friends. And if you're on my page and on this, you might be doing it because you want some information. So I never say anybody's names. I don't like to record anybody's names, but just thanks for the support. Hopefully it helps you or somebody that you know, or you can obviously pass it around, pass on the news. I'm also doing a live webinar as we speak, and it will be posted on my YouTube page and my Micklin Law Group website. So back to the material. So again, make sure it's in writing. How are the child custody laws applied during the pandemic? So first, you have to recognize this is uncharted territory for everybody. And it came out of nowhere. There was no warning. There was no preparation. And nobody, not to say few people, have lived through any experience like this. So we're kind of still finding our ways through it. It may even be over before we learn how to handle it. So you need to understand that everybody's in this kind of abyss of trying to figure out what to do. Nonetheless, as I mentioned before about court orders, the laws still apply. They haven't been changed. They haven't been stayed. Your orders are still effective. As far as legal rights and responsibilities, nothing has changed when it comes to custody and parenting time. The next slide just mentions about modification. If it doesn't revolve around COVID-19, then it shouldn't have any effect. The COVID-19 quarantine shouldn't affect the reasons for modification. Really beyond the scope of this, I just wanted to touch on that. You may have reasons modifying your custody or parenting time schedule at this time unrelated to COVID-19. Be aware that they're going to want to know what the effects of it have been in relation to the change you have. Like, for instance, if you're moving or a new school is starting and you want to change parenting time, the COVID-19 issue is not the reason for the modification, but when you think about it, it's still going to be applicable. For instance, if it's a school-based issue, whether or not you're going to have physical school in the next few months is questionable, so may or may not be good to address that if you're looking to change custody or parenting time based on that reason, for example. All right, so let's look a little more generally into custody laws and what courts will look at. Ultimately, whenever you're talking about a child, whether it's custody, parenting time, child support, whether it's in or out of pandemic, you're always talking about the best interest of the child. Paramount concern. Okay, so I just saw a note that I might only be seeing one slide. So that may be, I may have forgot to share the screen. All right. My apologies. We are 15 minutes into it, and everybody's been looking at one screen. So hopefully information was interesting enough to keep you tied into this. Let me real quick, if you see a new slide that says child custody law during pandemic, the interest of the child. By now, I don't think the attendees can, again, see one another because of confidentiality. Real quick, let me see from somebody. All right, so you're down. Okay, yeah, so my apologies. I didn't realize I stopped sharing the screen, which I should never do that anyway when I was waiting to sign on. If you do want the slides, they're attached. You can download them. So getting back, best interest of the child is always the starting point, any issue, whether you're in a quarantine or not. So the custody law statute in New Jersey is the number NJSA 9:2-4 subsection C. I say that only with detail, one, because I'm not sure if you're seeing my slide, but you may want to run a web search instead of printing out this whole webinar PowerPoint. And putting that number into a web browser will usually bring you right to the actual provisions. I'm going to go through, there's like 14 different factors. And these factors, again, apply with or without a quarantine when it comes to any kind of custody arrangement, custody or parenting time. I'm going to tell you quickly what they are, which ones are or aren't as important to the others, quickly as I can, because there's 14 of them. I don't want to take too much of your time going through them. So the first one is parents' ability to agree, communicate, and cooperate. That's usually the most important, because you wouldn't likely be in court on a modification issue or contempt of court order if you could agree, communicate, and cooperate. Very important. Second one is parents' willingness to accept custody and history of unwillingness to allow parenting time. Can be very significant. The first part usually isn't. You wouldn't be there if you weren't willing to accept custody. But the history of unwillingness is significant. It's very common right now. A lot of people are refusing to provide parenting time in contempt of their orders, claiming that it's because of risks or the quarantine issues. But of course, they're being a little lenient about it. I think we touch on that a little later. But it's still something significant. The unwillingness and history of unwillingness. The interaction, child relationship with the parents and siblings could be both his or her natural siblings as well as step siblings. Not so significant unless you have a larger family, but when you're talking about these issues of parenting time and custody, the interaction with the other children is not so significant. History of domestic violence can be very significant. First of all, if there's a restraining order in place, temporary or final, carries a presumption of sole custody, which leaves the custodial parent with great discretion about decisions on issues like relocation. It doesn't affect the schedule that you will have in place. So history of domestic violence is most significant if you're coming to court during this kind of a period and there is a restraining order. expect your rights to be very limited, as well as your ability to get significant parenting time may be limited, in part because of the domestic violence and in part because of the quarantine. Number 5, safety of the child from physical abuse by other parent. Sort of related to number 4, but not. It's part and parcel of domestic violence. On a child is obviously violent also. But there could be safety issues about the house. There could be safety issues with other family members, history, drug abuse, unrelated to domestic violence of the past. This is obviously a very significant issue. Not always one that commonly comes up when you're there because of a quarantine issue, because your quarantine is usually because of the COVID issues. But nonetheless, it is an issue the court's supposed to look at, just not significant when you're outside of these quarantine issues, but less significant currently. 6 is the preference of a child when of sufficient age. So first, let me tell you, the sufficient age is hard to tell you exactly because there's no definition. My experience, courts start to listen. I'm 13 or 14. Rarely, I should say, I've never seen a court allow a child to make any decision about which parent they want to go with, live with, or visit with, because one, they don't want to put children in between both their parents. Also, they're often not able to make such a sophisticated decision. It's a very complex thing, and a lot of issues come in short term that children just aren't able to sort through as easily. 7 is the needs of a child. That could be mental, emotional, psychological, educational, religion. Again, this is an important issue. During the COVID-19, probably even a more significant issue than it otherwise is, because needs, and we'll talk a little bit about later, certain people and children are at higher risk than others. So this becomes a very significant issue during COVID-19 quarantine application. Stability of home environment, usually not so significant because parents generally, I shouldn't say generally, have stable housing. But when you go to a court, courts are going to assume that you're capable and qualified to be a parent. You're presumed to be capable. So you're going to presume to have sufficient needs to provide the child with home and financial issues. But during the COVID-19 issue, stability of your home environment takes on a different turn because you may have an unsafe environment because there's other people living with you. You might live in a very high congested apartment complex. You might live in a rural town or a metropolis. So these issues will significantly impact, more so than they would normally in a custody or parenting time issue. 9, the quality and continuity of child's education. Not so significant now because, probably even less significant than it used to be. It was significant before, obviously, but now, because most programs I know of are virtual, education can be continued and maintained in almost any residence as long as there's sufficient electronics and internet service, which is almost a staple now. So not as significant as it used to be. All right, moving on. There's still a couple more, those following the PowerPoint. Fitness of the parents, not a huge issue when it comes to normal custody parenting time, because again, you're presumed to be fit. Here, fitness takes on, again, a different meaning because you may be at a higher risk. And again, we touch on this again, but if you're, for instance, working in New York City as a police officer, no offense, that's a tremendous job that you do for us, but you are at higher risk of exposure to the COVID-19. So your fitness is going to be determined differently because you may be less fit because you might be intentionally creating a bigger risk to your child of exposure to the virus. Proximity of the two homes, that's still significant. If you have an order in place and your housing hasn't changed, it's obviously not relevant at all. It takes on a little bit of a new meaning again, not again, but the other issues, because you have a longer commute, you just have more risk of exposure. There might be taking more rest stops if you're living in different states, you have to stop for gas or get food. So it's a little more significant than it used to be, but not a deal breaker when it comes to enforcing or modifying your parenting time. quality time with the child before separation. And here I would say even and also before the quarantine. This is interesting because sometimes significant in your day-to-day custody parenting time, because if a parent is fighting to get more time and hasn't exercised time in the past, then it's usually not a credible argument. Here, if people had a set amount of time, a lot of people have a greater ability to have more time with their children than they had in the past, because a lot of people are working from home. And unfortunately, a lot of other people aren't working at all. So here, what used to be a hindrance is actually a good basis to get more time. I would argue if you had less time before, because you had, like, let's say, for instance, you were a fireman and you have like a 4-on-3 off schedule rotating, or a police officer, you would lose a lot of time because the rotation falls during the school weeks, and your weekend is in the weekend. Here, the children aren't going to school and they're not going to daycare, then your ability to spend more time with them, a different schedule, it's very significant, much more so than I think it would be outside of the quarantine issues. Number 13, employment responsibilities. Not so significant in your customary issues, other than understanding the work schedule so that they're making sure they're bringing with the children. Here, it's more significant because whether or not you're an essential employee, whether or not you're working at home or out, we'll tell the court whether or not there's a lot of risk or not, and whether or not that should impact the decision about parenting time, custody. And age and number of children, number 14, I think this is the last one, not very significant before or during a quarantine. It's obviously something the court's supposed to look at, and if there's a lot of children involved, maybe it would be significant because it might mean, again, greater risk. You have, for instance, other stepchildren, or you have current children with one spouse and you have parenting time with children from another relationship. Your spouse may be out working and putting the other children at risk, or your other children are coming from a different environment. So number of children may be significant, but only because it impacts where they're coming from and exposure. It's not the actual fact that you have more children in your house that's significant. It's that you're creating more issues and more risks possibly if you do, or at least that need to be addressed. All right, so changing custody during pandemic, always guided by the best interest, like we said. What you usually need to change is showing a substantial change of circumstances. Now, customarily, that change had to be first in the best interest of the child and permanent. So, and I say that, people used to think, and probably still do, getting a new job and moving somewhere or making more money would be a basis to change custody. That wasn't, or isn't necessarily, because that's a benefit for you. It doesn't really benefit the child. Bring the child to a better environment because of a better school, for instance, that might be. Just because you're moving to make more money isn't. And it needed to be permanent. Now, when you're looking at COVID-19, we're assuming the quarantine is temporary. Now, it's a long temporary. It may be longer than we anticipated. It's not a permanent change of circumstances. So while it certainly is substantial, it may be in your child's best interest. At this moment, you can't argue that it's permanent. However, I don't necessarily think that matters, because most of the relief that people are looking for is probably of a temporary nature. Most of the cases and complaints I'm hearing about are one parent refusing to have the parent take parenting time because of risks. Somebody's trying to increase their parenting time because they're home. So going to court because of the quarantine doesn't carry the same burden for changing, especially if you're asking to change it on a temporary basis. I would recommend that you consider doing that if you're currently going to go in for a modification or even an enforcement of an order. Is explain that it's temporary and that you would be willing to revisit it once the quarantine is over. One, I think the courts are going to want to do that anyway. And two, I think it strengthens your position and your credibility. You're not there trying to punish the other parent for not giving you time, looking to take away something long term, but just trying to do what makes the most sense in the moment than what everybody's dealing with. So let's talk about a few significant change of circumstances. And this kind of stands on both sides of your case, whether you're trying to get more time, you're trying to prohibit other parent from having more time. Noticing symptoms or confirmed COVID-19 diagnosis. I've had a lot of cases where parents have gone in, and I've even had some intact families that have gone in and said, I think my wife is, or my husband, they have the virus and I need them to be removed from the house or stopped from having parenting time. Not generally successful. Courts have taken the position, rightly so, I think, that you're a parent, you have a constitutional right to parent. Even if you had the virus, they don't have a right to come and just remove your children and take you from your house. There should be safety measures and obviously treatment issues. But from a legal standpoint, it hasn't really mattered. Potential change would be if one parent is confirmed to be around other people that have the virus. Obviously, it passes by close contact. If one family member has it, it is a substantial likelihood that it's going to pass quickly and rapidly through all the family. So that is an issue that you can ask the courts to consider. That child is a high risk, has asthma, allergies, severe reactions to the virus or its treatment, very significant. Also, if your parents are older, they're high risk, and treatment is more difficult. So if they're more likely to have the children who would be at the house are also at high risk. Here it says if you're using a cleaning service, really cleaning service, home health care service, housekeepers are high risk people because they are transient in the sense that they're going from houses to houses, especially healthcare workers. Fortunately, they're all there to help us, which is great. We need them. But a lot of them are in close contact and then coming into individual homes and bringing it into the house. So if you know the other side is using home health aide or housekeeper, that is a significant issue to bring to the court that they will consider when viewing modifications of your parenting time. There's daycare issues. Let's say, for instance, you're not working, but the other parent is working. The other parent's working, then they're going to need some kind of daycare. Now, daycares are closed, but they're going to be bringing in individuals, just like I mentioned before, home health care workers, cleaning ladies, people to watch their children. Those people are significant risks because their contact and their whereabouts are largely unknown. So a very significant reason to bring to the court for parenting time and custody issues. So, and as you can see from all these, they're very, very fact specific. The court's going to look carefully and usually quickly at all these issues to determine whether or not it is grounds to have a substantial change of circumstances warranting a modification of parenting time and custody. Let's talk about emergent applications. Most of the applications that I've seen that we filed are of an emergent basis. They're called an order to show cause, which is a short, expedited application. In the past, you used to have to actually go to court and fill it out, but obviously now you can't do that. So you can get forms online. Sometimes the courts can send out forms or attorneys can draft them. It's expedited filing, it's electronic filing for the application, which is asking for an emergency hearing on short notice. The standard is immediate and irreparable harm. There's a citation in here. I'm not going to read through it, but you might want to get the, I'll read this aside. It's Crowe, C-R-O-W-E versus DeGroia, E-G-O-I-A 90 NJ 126. If you type that again into a web browser, you usually come to the right case because it's a well-known case. It really just sets forth the standard for order to show cause for immediate and irreparable harm. I'll touch on them briefly. One, you have to show irreparable harm if it's not granted. You need to show that your claim is settled. And what that means is that you have the right to be seeking the change or the modification. Either that it's obviously it's your child and that you have your constitutional right to your child, or you have a prior court order entitling you to what you're seeking or to the remedy that you need. Likelihood of prevailing on the merits is significant, meaning you have to say to the court, it's likely I would be successful, so you should hear this more quickly. This nature of applications, if it is about parenting time, custody, and the safety of a child, likelihood of prevailing on the merits is always going to be very strong. And last, when there's rights on both sides, which there's normally going to be, the court wants to look at, and what you should be arguing is that the harm is going to be much greater not granting it than harm to the person whose rights might be violated. Sort of better to help us than hurt them is what the court needs to understand for an emergent application. A little bit more on an emergent application. So here are two case examples. I'm not going to, two actual clients that we've had. Give just a background to show you. The first one is we had a client who lived in Pennsylvania, a very rural area, a remote resident. He was not the custodial parent. He had parenting time. Mom was refusing to provide not even more, but just the agreed upon parenting time because of COVID-19 issues. And our position was the client should have more time because he's in a safer area. Mom's up here, and this was a while back. Well, not a while back, but like a good month or two back when the quarantine was just beginning, and things were still, unsettled at how much risk everything was. So we thought it made sense to have the children go with the father. They're not in school, in less contact with people. They have more space and room outside and moving around. And the court denied it, left the children with mom, and said, leave them with the custodial parent and give limited parenting time to dad. Now, the second case example, we had a client who lived in Newark with the children. No, I'm sorry. Lived in Newark with the children, and the father lived in also a very remote area. Wanted more time. In this case, not only did the court not give the time, it actually suspended parenting time altogether and only allowed the parent to have contact by FaceTime. So the differences between the two, first is I think they were both the wrong decision, and it's kind of why I'm putting them up here to show you that you don't really know what to expect. The first one, I thought the father should have gotten more time because I think the children were less risk, as well as the father had more time to have time with the children than he has in the past. Here, father, which wanted more time, less time, didn't even get the time that he originally had, eliminated his contact altogether, and he was not at great risk because he was in a rural area. He only has FaceTime. Now, in here, we note that there was a restraining order in the past, and that could be partly what influenced the judge's decision, as I mentioned earlier. Domestic violence and safety of the children from domestic violence is a significant issue and something the court needs to look at. And sometimes when you're in a case like this, and the issues are close, and it's a hard call for a judge to make, it's issues like other 14 factors that may tip the scale one way or the other. Policy modifications, tips, and action items. First is file now. I've been telling everybody this, and it's not because I'm trying to get more clients. As much as I love having clients, I have enough clients. Say I won't take on more. But courts, and I'm sorry if any of them are listening or happen to hear this in the future, the courts are getting worse with managing their caseload than better. And they quickly adapted to the no contact with video conferencing, electronic filing. And at the beginning, they kind of just put everything on hold. And then they kind of just pushed everything down until another day. Then things were picking up a little bit. Then all of a sudden, they stopped. Everything slowed down again. They stopped with video conferencing, went back to phones because I think they were just having too much trouble coordinating video conferencing, which I think is much easier than getting 4 people on a telephone at one time. They're starting to adjourn cases again. So I don't have a good feeling about the backlog that is created. Now, another reason is everything is still being done virtually, whether it's by phone or in person. There's no court appearances. That's significant because I've been telling everybody part of the reason why litigation is so expensive is because of court time. You're normally scheduled for 8:30 with 15 other cases. If you're lucky, you're out by 12:30 or 2:30. Sometimes it's 4:30. Sometimes you don't even get heard and come back again. This is hours and hours of wasted time you no longer have to do. I have a case management conference or a motion hearing. sit at my desk and I'm working until my phone rings. So what used to be a 3, 4, 5 hour billing item for a client may be like 30 minutes. So there's countless thousands of dollars being saved in litigation by filing now. You also don't have travel time, you're not paying for parking, not taking off work. The client or herself is saving a fortune. And I don't want to sound like I'm all, money obsessed, but when it comes to litigation, the thing that keeps people from doing it usually is the cost, or at least doing it right with an attorney is the cost of it. I'm also concerned about the backlog that's developing. Not only do I find courts now starting to adjourn and push dates back again, because like I said, they started to pick up the pace and then they quickly stopped. I haven't had a single trial that was set actually go forward. I haven't seen any indication, protocol for a trial other than submitting documents a week in advance. I don't think the courts are ready to do trials just yet because there's going to be significant issues, appellate issues about marking evidence, credibility findings, cross-examination rights. It's going to be a mess. And so in addition to the fact we have all these cases being kicked to the curb that are going to be heard in a month or two, you also have circumstances that are developing in people's lives that are going to force them to be filing later, like modifications to alimony and child support, for instance. You really can't do that for 90 days. Well, quarantine's been about 90 days, maybe even for some longer than that. So right now, people are only at the time where they could be filing. So they're going to start filing in mass amounts, possibly, for people that are suffering financially. So now we have the two issues. We have all the backlog cases coming up, the new cases going in, and we have them having trouble dealing with the procedure and not giving trials. It's going to be possibly a mess. And I'm generally an optimistic person, but I'm not real optimistic in the short term of how courts are going to handle this. So I've been urging clients, if you're going to be taking action, take action now. Now, not to say I'm saying hire us and let's blaze in the court. There are other options. Before and during and after this quarantine, I'm always going to encourage people to work at coordinating and cooperating with the other parent. First, if there is a concern, make sure it's a genuine one. If it is, then take steps to make sure that concern is addressed. Let the other parent know that if you're the parent who's having problems getting parent time, let the parent know that you're taking precautions. Possibly get tests to show that you're clean of the virus. Give proof that you're not working. If you are the custodial parent not giving parenting time because you're concerned, ask for these things from the parent and do it in writing. Ask for it so that you can see if there's a genuine risk or not. Again, as I said before, unless there's a restraining order in place and you can't communicate with one another, you can, and here's another issue, I'm not really sure if the courts are set for this, but normally you'd be coordinating through the family division, domestic violence, because addresses are often confidential too. They may be able to facilitate conversation and they may not be able to. That's what you should be doing. You cannot have contact with one another any other way. As I said, if you're going to be addressing these concerns, make sure it's in writing. Emails are fine. Text messages are good. I'm not a big fan of text messages personally because they're hard to reproduce. There's such a volume of them. I like emails better, but writing's a writing. So whatever you can get, it's going to be good. And make sure that you're following the guidelines properly. Make sure that you're exercising proper social distancing, that you're wearing gloves and a mask when you're out, that the people that you're in contact with, involved in your life, that you might be working with, make sure they are taking all of the right precautions. If your child is with another parent or another family member, make sure that they're taking all the proper steps and everybody in their house is doing so. Nothing wrong with being rigid about finding this out. Doesn't mean you need to use it as a basis to stop parenting time, but you have every right to make sure all parties involved are taking the proper precautions. Now, if you aren't sure that the proper precautions are being taken, before you go and break your court order, the reasons I mentioned all throughout this webinar, talk to somebody about it, preferably a family law divorce attorney that understands the area. The courts can't really give you much information. I never recommend talking to anybody who's been through it because they'll give you a horror story. I also don't recommend going to the internet, despite the fact that you're listening to this on the internet, because you can find an answer to anything if you type the right words on the internet. It doesn't mean it's the right answer. So use caution, but speaking with an attorney is usually going to be a safe first bet. If you're going to be discussing and resolving issues, offer to make the changes temporary. As I mentioned in the beginning, when you go to court, tell the judge you're only looking to make things temporary. You make an agreement with one of the parents. make them understand that it's only temporary. Make an agreement in writing that says you're going to review it when the quarantine is lifted, when the risk of the COVID has been eliminated, whatever point in time you think is appropriate. Here I have a recommendation. You can contact police department for to force exchange. Doesn't usually work. Now, I have it in here because it's an option. To be fair to everybody, not one that I like. I don't usually recommend it that you do it, but certainly it's an option. Some police will get involved and indicate to one parent that breaking a court order, the other parent came and they're here to cooperate. One, it can be detrimental to your child to see the police officer come. Sometimes the lights are on. It's obviously a show of authority. Children pick up issues. They wonder why the police are coming for their parent. Not always the best move. And technically, they really have no authority to make you do or not do anything. Many of them try to suggest that they do, and some of them even tell you that they do, but trust me, they don't. As helpful as they try to be, they have no authority whatsoever. And if you're not comfortable with that, make sure that they know that and speak to an attorney if there's going to be an issue. But you have an absolute right to refuse whatever a police officer says to do with your child unless he or she, the police officer, has a brand new court order saying that the police can enforce the terms of that custody order. I'm going a little deep in that. It's kind of a soapbox issue of mine because people are often intimidated by police who are improperly trying to influence and impact custody issues, and they're not entitled to do that. And it increases tensions when you call the police officer. Obviously, other parents going to be up against the wall, upset with you. The child may be upset with you, or the other parent, the custodial parent, for causing the situation. It's just a bad situation. So I put it up here to let you know that it's an option, not one that I recommend ever. In fairness to you, it is an option. All right, so that's the information. I hope it's helpful to you. I hope it helps you or other people that you know. I'm going to see if anybody posted any questions. I always have a problem like opening this window. Okay, here we go. Oh, by the way, I hope the slide thing got resolved. I didn't see any more comments. All right, so I see a question here. Let me open this window. It looks like all right. So I'm going to open the whole window. That's it. No, I just closed it. I sometimes run into problems getting this maximized, and then I miss other. So I'm going to read the question out loud, not who posted it, because you can't see one another when you sign on here. A non-custodial parent is asking for additional parenting time based on being laid off from furlough. The custodial parent is also laid off. Is it necessary to get the non-custodial parent extra parenting time on top of what they already get? Does a custodial parent look bad if they keep with the custody order set? All right. So there's a lot of levels to this question. First, I always tell my clients, don't worry about looking bad to a judge when it comes to making issues about your child and your legal rights. Judges are great people, and they take a great amount of time to make sure they do their job right and take care of their families. It is their job, and they have a lot of cases, so they're not likely to remember you when you go back. So don't structure your decisions based on what you think a judge is going to think. Also, because you don't know. The judge may understand your basis for making a decision, and you're the parent. You have a right to make the decision. That's another soapbox of mine. Don't worry about what the judge thinks. Now, is it necessary to give the parent time? Here's how I read your question. Go off and you're home all day. You're going to go on the assumption there's no great risk on either side, so there's no compelling reason why either parent should have it. My personal answer is you should give as much time as you can. The law presumes both parents should have as much time with their children as possible. If the person asking the question, or in the scenario, the person making the decision to give more time, probably had more time with the child or children before, it's only fair to give more time to the non-custodial parent. It's helpful for you because it gives you sort of a break. A lot of parents don't realize that sometimes not having their children for a little period of time is a good thing for them and the children. And you may get more cooperation in the future. The nature of your question suggests that this may not be the first time you had the issue and that you may have order in place for this very reason. It's always nice to give something and get something in the past. So short answer to your question is yes, not that you have to or you look bad, but I think that you should because I think it's good for the relationship, you and the other parent. I think it's good for the child. And if you're not so comfortable about that, take the advice in here. First, make sure it's in writing. Second, make sure that it has a termination and reversion period, not the we'll review it when the COVID's over. You say when COVID quarantine is lifted, the child returns to me or the parenting schedule returns to the way it was. No question or ambiguity in that. You can make sure that you're not giving something permanently away. And lastly, maybe get something in return. Now, again, this is not, in my opinion, the best thing, but it is my best advice for you, and that is something when you give something. So if you're giving more parenting time now, ask for another holiday in the future. Ask for more summertime. Ask for another school vacation that you might not have. Ask for extra child support. Ask for anything. And if it's reasonable and it's refused, then you're more justified in refusing the extra parenting time because, again, it's a get and give. So I hope that helps you. If not, you can always email me with more information, more questions, or more details if you didn't answer it. My email is brad@micklinlawgroup.com, Micklin, lawgroup.com, all one word. Part of that question now had an answer. There are neglect issues causing more concern. Okay, well, and I can't really address that. I don't know what neglect issues you mean, and I don't know if you mean abuse and neglect, meaning the legal term that DCP&P, formerly known as DIFUS, is involved, or there have been previous cases, or you're concerned that the other parent is just neglectful. That goes back to some of the issues I covered in here. Is the house safe? Are they taking precautions? Are they in contact with other people? Are there other people coming in the house that are in contact with other people? And these are all significant, relevant concerns of yours that you have every right to make sure are resolved before you even consider giving more time. My presentation today is more about enforcing the time you have or modifying the time. So when you're talking about should you give more time or not when there's neglect issues, it's exactly what I was trying to cover through all of the slides before. So hopefully the information throughout your presentation helped you. I know that you posted the question like 20, 30 minutes ago, so hopefully it was answered. Is there any other questions on the webinar? Yes, because I'm not seeing any pop up. Quick hello to some people on Facebook just tuned in. Hope this helps you. If not, if you're not here because you need the help, you're just tuning in to have something to do. Good to see you. Thanks for coming. You can message me here through Facebook Messenger if you have any specific questions, or just email me at the email I said before, brad@micklinlawgroup.com. I don't see any other questions. It is 7:20. Oh, by the way, I should have said this in the beginning. Today is May 28, 2020. I always go through this spiel in the beginning of my webinars that it applies only into New Jersey law and only applies on this date. If a future date circumstances have changed, you need to make sure it applies, make sure the law isn't applied. That's even more significant here, but probably self-evident because we're talking about the quarantine issues, COVID-19. If quarantine is listed and or there's a vaccination or a dissipation of the virus, everything's going to change anyway. But it's still important to understand it is limited to date and time. Laws change rapidly. You always need to update to make sure you have the most recent. With that, I thank those that signed on to my webinar for attending. I appreciate the support of my friends and family on Facebook. It's always great to see people here, especially at times like this when I don't really get to go out and see people. So I hope it helps. And if you do, please go to my social media, like the information. The recordings will be posted on my YouTube and my website. You can subscribe so you get notices when I go online. I try to do a tip. I used to do a tip every day and change it now to be every week because I wanted to make it more informative and better video. So I'm giving you hopefully better information, just fewer. So you can subscribe so you know when I do post them. I usually get them up by like Wednesday, Thursday. So if anything you want to see, message me and I'll do my best to include it in upcoming webinars or videos. With that, I'm going to sign off. Again, thanks for coming and everybody stay safe. Some family saying, I can say hi to Bruce. I can say hi to him because I always say I don't recognize people by their name because they could be here for information